that? Ding. Isn't that great? Good afternoon. I call this meeting to order. Welcome to meeting number 13 of the House of Commons Standing Committee on Citizenship and Migration. Before I start off with a few reminders, I would like to warmly welcome. We have students and guests from Tobago who will be viewing part of our a meeting today. So just want to say a warm welcome to all of you. So in terms of general comments and reminders, kindly wait until I recognize you by name before speaking. Please do not speak over each other, as it will be hard for our translators to translate, and it makes their job very difficult. Ensure all your comments are addressed through the chair. And please raise your hand if you wish to speak. The clerk and I will manage the speaking order as best as we can. So with that, pursuant to Standing Order 1082 and the motion adopted by the committee on October 23rd, 2025, the committee is resuming its study of subject matter of Bill C-12, an act respecting certain measures relating to the security of Canada's borders and the integrity of the Canadian immigration system and respecting other related security measures. I would now like to welcome our witnesses for our last panel regarding C-12 and our last hour of study. From the Canada Border Services Agency, Aaron McCrory, Vice President, Intelligence and Enforcement. From the Department of Citizenship and Immigration, we have Mr. Jason Holman, Director General, Asylum Policy, and Tara Lang, Director General, Integrity Policy and Programs. And from the Department of Justice, we have Karen Hamilton, Senior Counsel, IRCC Legal Services, and Anna Lillycap, Senior Counsel, IRCC Legal Services. And I understand that it'll be Mr. Holman who will be making an opening statement of up to 5 minutes, after which we will proceed to a round of questions. Mr. Holman.
Merci, Madame la Présidente.
Thank you, Madam Chair. Thank you for the invitation to appear and provide further information on the immigration measures in the Strengthening Canada's Immigration System and Borders Act.
To challenges and potential challenges to the asylum system. Through new ineligibility provisions, Canada will deter misuse and prevent further surges in an already strained system. The first ineligibility would apply to claims made more than 1 year after first entry into Canada. With recent changes to immigration levels planning, we know that some people were hoping to stay and may no longer have a pathway to do so. We want to discourage them from using the asylum system for that purpose. The second ineligibility is for those who cross the border irregularly and make an asylum claim 14 days or more after entry. Claims after the 14 days effectively evade the Safe Third Country Agreement, which is designed to manage asylum claims across our shared border with the United States. This ineligibility safeguards Canada against future surges of claims. Le Canada continuera à respecter ses obligations légales.
Canada will continue to meet its legal obligations for those claims are found ineligible for referral to the Immigration and Refugee Board can access a pre-removal risk assessment. In the risk assessment, trained officers review each case on its own merits. They use the same country condition information, and unless the applicant is inadmissible on serious grounds, the same grounds for protection. In all cases, officers will assess if there's a serious credibility issue, and if so, an oral hearing will be held. Applicants can seek legal assistance and make submissions regarding the risks they face. New material can be provided for consideration until a decision is made.
Future decisions. For example, the majority of PRA applications today are rejected because applicants have already been determined to not require protection by the Immigration and Refugee Board. Only new evidence is reviewed, and so many cases stand by the original decision. These measures will alleviate some pressures on the strained Immigration and Refugee Board. In addition to the ineligibilities, the legislation would improve the asylum system to address current inventories and reduce timelines. It removes bottlenecks and streamlines processes so that cases move as quickly as fairness allows. Le projet de loi C-12 prévoit également des nouvelles dispositions législatives
Bill C-12 also introduces new legislation to better manage immigration documents and applications, improve efficiency, and reinforce the integrity of Canada's immigration system. It'll allow greater flexibility to respond quickly and responsibly in times of crisis or uncertainty. To be clear, there is no particular set of circumstances where these authorities will be used, and the legislation does not predetermine scenarios for use. Rather, the authorities will be available for use against threats to Canada's national security, public health, ability to safely manage the flow of people coming into the country, or other matters of public interest.
Immigration documents will be automatically cancelled as a result of this bill. The use of these authorities would require a separate cabinet process. The Governor and Council would determine if an intervention is in the public interest based on all relevant considerations, including the impact on vulnerable populations. These authorities are limited to interventions on immigration documents and on the applications for those documents. The new authorities cannot be used to cancel asylum claims or revoke people's status in Canada. Je répondrai volontiers aux questions.
I welcome the committee's questions regarding the legislation and the immigration system. Thank you.
Thank you, Mr. Holman. And now we will start our rounds of questions. The first round is for 6 minutes, and we'll begin with Ms. Rempel-Gardner.
Thank you, Chair. In 2012, former Immigration Minister Jason Kenney used one-time legislation in the 2012 budget to cancel specific applications. Why does the government need the powers outlined in this bill for application? Like, why couldn't you just put it in a piece of legislation?
Thank you for the question. So currently, no authorities exist to cancel applications en masse. The 2012 Federal Skilled Worker Inventory Elimination was accomplished through legislative amendments.
Right, but why couldn't you just do a piece of legislation?
Because it doesn't allow for the flexibility to define the public interest as well as...
Okay, so you, as the bureaucracy, want to be able to determine that without going through Parliament.
No, the policy intent is to be able to quickly respond to emergencies, crises, health issues.
So why didn't you define what public interest means in the legislation then?
Because there are so many potential instances. So that's why we were trying to say health, security.
But why isn't that defined in the legislation?
Because it just would too closely, I think, restrict us to only being able to apply a recommendation to the OIC.
It's a fairly big devolution of power to the bureaucracy from Parliament. And I'm trying to understand, because there hasn't been an instance given by you or the minister, an example of where that would be used, why that couldn't be achieved by legislation.
So may I offer some examples? Thank you. So quickly facilitate the extensions or stay for temporary residents in Canada following a significant natural disaster. When intelligence is received from security partners, if there's a suspected specific threat of foreign interference, electoral interference, espionage, we could pause any kind of applications in that process.
Why didn't you include a report to Parliament as part of the use of these powers?
Well, I think that we were trying to clearly indicate that there is no clear one path for the use of these powers.
Except for legislation, which has been used before, correct?
Right, which is a very defined portion of a one-time elimination of a backlog. It doesn't involve applications
so it's
or
the backlog.
documents.
Okay, so we've now got to the heart of the matter. Did you guys include this because the backlog's so big and you need to kind of a little bit?
So this is exactly why we didn't go with one-time legislation, such as was what was done in 2012 with Minister Kenney, because
Okay.
that was a one-time elimination of a backlog.
So you just talked about backlog,
The
so would you
intention
ever
of
use
this
it to clear a
has nothing
backlog?
to do with
Chair,
backlogs.
point of order. Point of order, Chair.
Thank you. Point of order, Mr.
The
Frederick.
witness has wanted to offer a full statement back. I'm not sure she's had the opportunity to do that on a few occasions here. Let's just allow for that.
Please let her answer the
It's also
question.
not a point of order. Thank you. So I'll just ask again. So you brought up the point of backlog. I'm trying to figure out why I should support this. I'm on the fence, honestly, because it's a big devolution of powers. We've had a lot of witnesses say that I shouldn't. And I'm like, I need you to convince me, because the department has messed up. You guys have, you've said that there's fraud. There's a huge backlog. We all get casework. And now you're telling me that I should give my powers as a legislator to you without any report to Parliament. Why should I trust you?
So, I mean, I think the checks and balances are present there. The transparency through the publication of the Gazette, the conversations that we'll have
What
with
would be published in the Gazette?
any potential options around the public interest to suspend,
What level of detail?
cancel. Very detailed. It would have to be down to the type of application, the type of person. It would depend on the situation. It could involve like I was saying before, in a healthcare situation, if we needed to mass extend healthcare workers because of a crisis in Canada, it would have to specifically say these applications of people who are already in Canada, they would be extended.
Okay.
The level of detail is there. But if going back to the legislation that was tabled in 2012, that is not nimble. It doesn't allow us as Canada
I know,
to
I
respond.
have a problem as a legislator giving you these powers, right? It's a big devolution of
Right.
powers, and I feel like the department and the minister hasn't done an adequate job. And what I would encourage you to do in the short time that we have left is explain this in more detail, because you guys got roasted by the legal community, ethnic media. There's a lot of fear over this right now, and I don't think you've adequately communicated what this means. And that's a problem for me as a legislator.
Right.
I have another set of questions with the time I have left. We heard this week that your department, as part of the bill review, had really kind of devolved the screening of asylum claimants through the use of this one-touch system. It was reported to committee by the head of a union, and it's very concerning. We also had stories from Global News that Hamas terrorists have been granted asylum claims. Your department couldn't answer an order paper question on how many citizens, criminals you gave citizenships to.
30 seconds.
What's going on with this one-touch system? Let's start there.
Perhaps I could answer that, Madam Chair, and I'll try to be quick. I'll touch on why we introduced One Touch, how we went about developing One Touch, and what One Touch is. And in fact, cast your mind back a few years ago, we were facing fairly significant volumes, overwhelming volumes at the border. And what we're
Hashtag welcome to Canada volumes. Yes.
Ms.
and we were-
Rempel-Garner,
and-
kindly let him answer the question.
And so at that time, the practice was to actually adjourn a lot of these claims. And what that did was actually to push the risk inland and actually push the volumes inland. And this committee itself observed the number of the delays it was taking to get eligibility decisions with that practice. And so, in fact, our frontline staff, who were looking at how can we do this better, how can we do this differently, worked to develop a new process, which is what.
It's a self-declaration.
Ms.
That's
Rempel-Garner,
not-
your time is up. I was just allowing our witness to complete his answer.
So fundamental to One Touch is it is not a self-declaration. In fact, the front end of it involves an in-depth review, by face-to-face interview, collection of biometric information, assessment by a highly trained and experienced border services officer who will make a determination based on the level of risk. Based on that level of risk, if the risk is low, we will then allow the administration portion of the assessment to be moved
Was the
inland.
head of the union lying? Was the head
I'm
of the
sorry.
union lying?
Thank you, Ms. Rempel-Garner. Thank you, Mr. McCrory. Next, we have Mr. Zuberi for 6 minutes.
Just pick up on the line of questioning that was just had about the One Touch system. And just to understand better this situation, does the One Touch system, is that the only check to determine around security issues for someone who is going through that process of the One Touch system?
Perhaps if I could continue. So in fact, there's that initial face-to-face risk assessment, biometric information collected, run against our databases, run against CPIC police databases. There's an assessment of risk that is done by our experienced and trained border services officer. They will make a decision at that point. If they're low risk, we'll move the file inland and allow the administration portion of the assessment to be done inland, in part by the claimant, rather than having a BSO do a lot of data entry. If they're deemed to be high risk, we complete the full process right there at the port of entry. A minister's delegate, a more senior official, more experienced official, will review that work prior to the decision being made. to your point, to your question, that is not the end of the review. So 100% of in-Canada asylum claimants go to our Centre for Immigration and National Security Screening for an in-depth security review for each and every one of them. There's a fairly significant inventory there, but we go through each and every one of them and do a risk assessment on them. Further, both IRCC and CBSA hearings officers will review cases to look at which ones should we go to IRB and challenge the application for asylum based on a variety of factors. So in fact, there are multiple layers of defense. The first and foremost is our BSOs at the front line who meet each and every one of them.
I appreciate that answer, and it gives a lot more clarity to this question that we've been looking at over this today, but especially our last meeting. So this is really helpful, that level of detail. Now, getting back to the question that was discussed earlier around the public interest. This currently, as it's written, is quite broad, and it leaves a lot of room for discretion depending upon however cabinet is of the day. And don't you think that you can fashion this in a way that's still broad, but also narrows the scope a bit, where, for example, use terms like in exceptional circumstances, something that clearly narrows the usage, because you just did testify that it's in very exceptional circumstances, such as a menace to public safety. You said santé publique, public health, COVID-19, for example, very exceptional situations. But the way how it's written right now, it doesn't narrowly focus the mind to very exceptional situations. Do you think that we can do something to fix that up? If you just want to plead the fifth, you can.
No. I mean, I suppose it would be possible to define public interest to mean safety, security, emerging threat, crisis.
I mean, you could put in like a non-exhaustive list, includes X, Y, Z, and that's done regularly in law. Those who have studied law know this, or our lawyers know this. And
Yeah, I would have to defer to Department of Justice colleagues about the limitations around that, because it is purposely undefined to account for the unknowns.
Which is normal. In law, law should be written in a way that it does pass the test of time, but it should also be written in a way that does direct the civil service to apply it as the legislator intends, as you are intending, which is very narrow at this point in time. So I'm happy we got that on the record. Now, we did hear from a number of groups, in particular UNHCR and Canadian Canadian Association of Refugee Lawyers and other groups, about the PRA process. And the way how the PRA process functions right now is that it is a process of last resort after other processes have been exhausted. But way how it will be used in this legislation, it will be a process of first resort. So in terms of what we heard in this committee testimony, we heard that international pacts and covenants, which we have ratified, which effectively are our law now, domestic law, require that, from my understanding, that there is a hearing, an in-person type hearing. As it's written right now, there seems to be a bit of a void in that regard in order to be in conformity with our law and this current piece of legislation. What can we do to close that gap?
So maybe I can start. Thank you for the question, and then I'll ask my justice colleagues to comment on the last piece. But I mean, just to be clear, there are other groups who are directed towards the pre-removal risk assessment stream who are ineligible claimants today, who are effectively under that mechanism as their first determination. So it's not. I
understand your position. So I'll get one last question. And in terms of we heard about 2 points. One is that there was a salient point about first entry into this country versus latest entry. That's a salient point.
30 seconds.
And on this one point, I'd like you to respond to, which is there were some classes of people, minors, moratorium countries, survivors of gender-based violence, LGBT people. There are a number of categories where the 1 year doesn't work well for them. Have you? Do you have a commentary on that?
Quick response, please.
I can respond on the first piece effectively, the measures are designed to help deter people who might be looking to misuse the system. Changing the measure to most recent entry may not serve that deterrent effect, in part because people may look to leave the country quickly in order to reset the clock and come back, potentially by using the land border with the United States and coming right back again. So we may not see the deterrent value or the operational impact of the measure. The legislation does allow for the creation of exceptions at the regulatory stage. Those affected by the moratorium countries are a group that are affected by the pre-removal risk assessment process today. Those individuals, while they may not trigger a pre-removal risk assessment until their removal, are in Canada and safe from the persecution that they are claiming to be facing. They will receive a work permit and interim federal health while they're here, and as soon as country conditions improve, they would get access to the PRA that would proceed with the determination.
We've gone way past, but thank you so much, Mr. Zuberi. Next, we have 6 minutes pour Monsieur Brunel-Duceppe.
6 minutes for Mr. Brunel-Duceppe. Thank you, Madam Chair, and thank you to the witnesses for being here today. I will address the representative from IRCC first. There's a lot of criticism about the bill from groups that defend the interests of immigrants, such as Amnesty International and so forth. They tell us that C-12 will restrict the rights of asylum seekers if it's implemented as drafted. What do you respond to those people when you hear that criticism?
Thank you for the question. The ineligibility measures that are largely being commented on are designed in large part to prevent misuse of the system. That said, we do want to make sure that Canada fulfills the protection obligations that we have, and that is part of the reason that we are ensuring people get access to the pre-removal risk assessment prior to being subject to removal. That assessment process, I know questions have come up, but effectively looks at the same protection definitions as the IRB process. It does have a lot of guidance and training that are provided to the officers who are doing those assessments. They look at the same country conditions that are being explored. They do use hearings when credibility of the client is at the root of the decision. The paper-based process allows for us to look at certain situations where people might be facing an easy yes. So, for example, they look at the country conditions that might be being experienced, and it might be easy to determine that somebody should warrant protection. So there is a robust process there that has stood up to the court challenges as well.
J'ai comme l'impression que...
I get the impression that the risk assessment is used a lot in your department to justify Bill C-12. If we compare this, if we compare people that do succeed in remaining in Canada after a removal order, what are the statistics? Do you have the numbers of people who can stay after a risk assessment? What percentage of them can stay?
As I mentioned in the opening remarks, it's difficult to compare the approval rate today to what the approval rate will be for the new group. In large part, the majority of people...
La question était simple.
My question's a simple one. Right now, what is the percentage of people who, after a risk assessment, remain in the country?
The approval rate today for those who are subject to the pre-removal risk assessment is 14%. However, the majority of those are people who have already gone through the IRB
Donc, on était
hearing.
14%. Il y en a qui...
So we're at 14%. Some were saying between 6 and 14%, or around 10%. So what you're saying is this will change with C-12 in place. Far more people will obtain a visa after a risk assessment because they weren't able to file their asylum claim. Is that what you're saying?
They would be getting their full determination.
Okay, fine. So what I understand then is it won't change anything, since in the final analysis, the person cannot make an asylum claim after the pre-removal risk assessment. They will remain on the Canadian territory. So what will change, in fact?
To avoid sending claims to an already overburdened Immigration and Refugee Board that has significant inventories today. The pre-removal risk assessment process does offer an approach to protection that meets our obligations and is a faster...
Yes, I understand that. Allow me to stop you here. I understand what you're saying, but what you're telling the committee now is that people will not, it won't be IRCC officers who will deal with these asylum claims. It'll be people who sit on pre-removal risk assessment boards. So what I understand is won't change a darn thing, and we may undress Paul to dress Peter. Applications will be dealt with elsewhere anyway. So excuse me for telling you this that way, but what I understand here is it won't change a thing. You just explained that. I have questions for the representative from the Canada Border Services Agency. Recently, at the last committee meeting, we had the union president before the committee. He said that C-12 does not have additional powers that have been demanded for a long time by the union. For example, being able to patrol outside border stations. So, as he said, it would be far more beneficial for the members he represents to have this power. It's really administrative. You could do that right away. You don't need legislation. Why hasn't that been done?
Thank you for the question. Really what it boils down to is we actually have a very, I would argue, very effective system in Canada where we have our colleagues in the RCMP who are responsible for patrolling between ports of entry, and we're focused at ports of entry. Our border services officers do a very good job at those ports of entry, and they're very focused, and they're dealing with lots of work there. And our colleagues in the RCMP are doing the same thing. So I'm not sure what the benefit would be to take our officers away from a port of entry and have them duplicate what the RCMP is already doing.
Donc vous dites que la demande, une des demandes.
So you're saying that one of the union's demands, that of its members, is pointless and shouldn't even be heard. Fine. So the same union president was telling us that, in his opinion, if C-12 is implemented, he doesn't have the staff necessary to have this bill be effective. Do you agree with him?
But you can give a quick answer, please, Mr. McCrory.
I don't agree, but that's also why I don't want border services officers patrolling between the ports of entry. We want them to apply to the work that we currently have and focus on those efforts.
Okay. Thank you so much, Mr. McCrory. Next, we move to 5-minute rounds. And just to remind the witnesses, if you want to respond, just get right on into it, just because we have lots of questions in a very short period of time. So don't feel like, oh, who wants to go? Just whip right on in there. Okay. First up, we have Mr. Redekop for 5 minutes.
Thank you, Chair. Mr. McRory, so just carrying on this point, so Mr. Weber essentially said the one-touch system is a terrible system. You seem to have a different opinion. So was he lying, or like where's the misunderstanding here?
I don't think he's lying. You know, interesting, like for me, one-touch, one of the things that really impresses me about that system is, as I noted, it was developed based on recommendations of frontline staff who are dealing with the issues at the port of entry.
And yet the union leader is telling me that it's a terrible system.
Yeah, you know, he's entitled to his opinion. Certainly, you know, and I think what One Touch is a change, and a lot of people don't like change. But what I think is really great about it is staff looked at how could we do things better, how could we do things differently. You know, there's always the tendency to want to throw money at a problem, and here folks came up with a solution that made us more efficient, but as effective, if not more effective. So I think it was a really great innovation in terms of ground-up people coming up with a solution. Change is hard, but I think we've come up with a good approach.
So I understand that. So what I don't understand, though, is there's a major difference here, because in his discussions with him, he said that the person does the app and they're in the country, they have to report in 45 days. You're telling us they actually see a person. So I'm not understanding which of you is correct here.
Well, there is no app. I think the C-12 contemplates a single online application portal, but in terms of
the one-touch system is not an application.
No. What it involves. Pardon me. Sorry.
What is one-touch?
Yeah, maybe the one touch. The idea is limited the number of touches we have on a person rather than pushing a button. But the idea is an individual shows up at a port of entry. They are assessed by a border services officer who goes through a series of mandatory questions, collects biometric information, does a risk assessment. On the basis of that, they will make a decision whether or not the person is eligible for the administrative portion of the assessment to move inland. And that's where the individual will enter tombstone data on a website.
Okay, so you're saying that this person actually talks to a person, and there is no application, which is the exact opposite of what we were told by the union leader. So he doesn't know what he's talking about, is what you're telling me.
I can't comment on what he said. What I will
Do you
tell
have
you
problems
is,
with the union right now?
pardon me?
Do you have problems with the union right now, or?
I actually, what I'd say is, for example, on a file like immigration detention, we have a fantastic relationship with the union. We have ongoing dialogue with them, and we're really working together to address the challenges we have in
So-
immigration detention, ensure our employees are safe.
One of the other things that he said was, and you said this too, there's a 45-day process afterwards. You have to come and do some things. And he told us, Mr. Weber told us, that about 10% of those people never show up. Is that correct in your opinion?
I'd have to confirm the data, and there is a timeline in which people have to enter the
Is
data.
it approximately correct? Sounds about right.
It's hard for me to say definitively. I wouldn't want to mislead you
But
by
it's not
by
zero.
guessing.
People
No, it's
do
not
not
zero,
show up
yeah.
sometimes.
But that's
So
no different than people that don't show up for their IRB hearing down the road.
So that means we have people who have gotten into Canada who are just here. We can't track them. You've lost track of them.
But I'd suggest that that's not an issue with One Touch. That is an issue that we confront more just generally. That's not a product of One Touch.
So you refer to these as low-risk claimants.
Yeah.
So yet we have people that aren't showing up. I mean, we have a unfortunate situation right now where we do have criminals that have gotten into the country. And so do you not think that, I understand that most people that come into our country are not criminals, but we do yet have them in our country. So they're getting through the system somehow. So is this a smart thing to do?
I would suggest that, first of all, and I've tried to convey the impression, we don't rely on a single layer of defense. No single layer of defense is going to be perfect, and so we rely, first of all, on that initial assessment by our Border Services officers, guided by strict mandatory questions that guide their risk assessment, including the collection of biometric information, and based on the available information that they have at that moment of time, they make a decision. But there are subsequent layers of defense, so that's where our Center for Immigration National Security Screening.
Okay, so, sorry, I'm running out of time here, but one of the other things that Mr. Weber said that was a little bit disturbing was he essentially accused management of being more about service than security. And so I guess on that piece of note, on that note, are executives, CBSA executives pay bonuses based on service metrics like processing times and things like that, or security in terms of, not allowing people to come into criminals to come into the country?
I can't comment on people's performance pay generally. What I will say is that as an agency, that is the inherent tension that we have. We want to move legitimate goods and people into the country quickly and efficiently, and we want to stop bad people and bad goods coming into the country.
So
my job, the fundamental nature of my job, is enforcement.
So
Thank you, Mr. Redekop. Thank you, Mr. McCrory. Time is up. Next, we have, for 5 minutes, we have Ms. Salmo-Zahid.
Thank you, Chair. Thanks to the witnesses for appearing again. So I'll continue this conversation, my round of questioning with Mr. McCrory. So further to, you have answered some of the questions raised, like the testimony from Mark Weber, the National President of the Customs and Immigration Union, was very worrying. So I would need some, if you can please clarify the steps when someone lands. For example, we will take an example of the Pearson Airport. So can anyone, whether a Canadian citizen or a permanent resident or asylum seeker, land at Pearson Airport and enter Canada without interacting with any real person?
It's a pretty broad question. Sorry, through you, Madam Chair, that's a pretty broad question. And so if you're contemplating somebody flying into Pearson Airport, there'll be a number of different ways in which they will come in. They may do an advance declaration. They may present themselves at a kiosk. On the way out of the kiosk, they will present themselves to a Border Services officer. So yes, there will be an interaction with a person. For somebody claiming asylum at a port of entry, 100% of them will spend time, and considerable amount of time, with the Border Services officer to do that initial risk assessment.
Yeah, so can you please clarify that can anyone claim asylum at a kiosk?
Not at all, no.
So can you explain what the steps will be if someone goes to the kiosk and complete their declaration?
You complete their declaration. If you're going to make an asylum claim, it'll vary from a land port of entry to an airport, but you'll present yourself and indicate that you want to make an asylum claim, and then you'll be taken off into secondary and go through a different process. And that's, again, where I suggest our first step is to do the risk assessment, to understand who you are, to assess whether you're eligible to enter the country, admissible into the country, eligible to make a claim, and establishing your identity. And so we have mandatory questions that guide that. A face-to-face interview is a part of that process. We collect biometric information. We run your name and your biometric information against our databases, but as well as against policing databases. It's a very rigorous process. Is it perfect? No, there is no perfect system, and that's why we have subsequent layers of defense. And only if you're deemed to be a low-risk asylum claimant will we allow you to move into the one-touch process and, as suggested, complete the administrative portion of the assessment inland, and requiring, and I think this is an important feature of it, requiring the claimant to enter data into the system rather than wasting the time of a highly trained and highly experienced Border Services officer doing data entry. If you do not meet those requirements, One Touch is one of 2 or 3 different ways in which we'll do an asylum claim. If you do not meet that low risk threshold, you will go through the full assessment process at the port of entry. Still doesn't mean, you still may enter the country and proceed with your claim, but the process will be completed at the port of entry.
So if someone is coming to Canada as a landed immigrant for the first time, and have they already undergone security screening?
So if they're coming on a visa, maybe I should let my colleagues from IRCC start with that process because we work together on that.
If they're coming as a PR?
Yes, they would already have completed security screening.
Okay, so one quick question I have is that, like we have heard from a lot of witnesses, that this new 1-year ineligibility for asylum claimants introduced by Bill C-12 would disproportionately impact the women and the minority communities, individuals, and other survivors of gender-based violence. So can you please tell us if IRCC has looked at how different groups like these will be impacted by these provisions, and are you confident that minority groups will be protected under this legislation?
Yeah, thanks for the question. In developing the measures, we did do a full gender-based plus analysis. Generally, it found that specific vulnerable groups would benefit from faster access to protection, which we hope to be able to provide for those who do merit it. The pre-removal risk assessment process that those impacted by the ineligibilities would be directed towards has guidelines and training for officers in relation to dealing with minors, gender considerations, cases involving sexual orientation, specific cases of vulnerability. They can also reference the same guidelines that are available to the IRB officers as well.
30 seconds.
Anything else in regards to the ineligibility criteria you would like to highlight, like about the processes involved?
I would come back to the earlier question about the benefits. Beyond those I already explained, back to the opening statement, one of the key things we want to achieve by those measures is the deterrent effect. So we are hoping to deter misuse of the system by those looking to extend their stay or those looking to evade the Safe Third Country Agreement. So besides the actual operational impact and the protections we want to make sure we have for people who really do need protection, we are hoping to discourage
Thank you,
some
Mr. Holman.
individuals from claiming.
Thank you, Mr. Holman. Thank you, Ms. Zaid. Next, we have 2 minutes et demie pour Monsieur Brunel-Duceppe.
2 minutes and a half for Mr. Brunel-Duceppe, please. Thank you, Madam Chair. I just want to get back to this for a minute. I understand what you're saying, Mr. Crowry, about the fact that you don't want your officers patrolling the border instead of the RCMP. I understand that. That's perfectly logical. However, what the President of the Union told us is if there's some information that something suspicious is going on near the border and that CBSA officers are in a better position to act quickly by intervening, right now, they don't have the power to do that. So what the union president was saying was that rather than call the RCMP, who will get there 6 hours later, they can be there within half an hour. So why don't you allow them to do it if there is a request by the CBSA Officers Union and if it helps the RCMP officers do their job? That's my question. It's really a question of logic and effectiveness, efficiency, and responding to a demand by the CBSA Officers Union.
The question I guess I'd come back to is really making sure that both organizations and other organizations involved in law enforcement are making best use of the resources they have, the most efficient, most effective use of the resources they have. And CBSA does collaborate quite extensively with law enforcement, especially in inland enforcement in context, but also in criminal investigations as well. But right now, in terms of the best use of our resources at a port of entry and the best use of RCMP resources, we think the RCMP hasn't come to us saying we need some more help in that regard.
Non, mais vos membres vous le demandent par contre.
No,
Ça, c'est-
but your members are asking you for that. It's quite incredible that you refuse when this is documented and has been proposed by the union who represent the members. However, I invite you to remain open to that kind of request. It might be a good idea for border security. Now, for the representatives of the Department of Justice, if C-12 was adopted as drafted, we're told it will end up with myriad cases and demands for reviews before the courts, that it will cause bottlenecks in the courts, that C-12 will be brought before the courts. So what do you expect exactly, and do we have the resources to face that kind of bottleneck in our courts?
Seconds, please.
So I think it's fair to say that new amendments often bring challenges before the courts. But I would note that, for example, in terms of the new ineligibilities, for example, while a person may seek leave and judicial review of the court of a decision to refuse their PRO application, this is also the case for anyone who reaches the end of the IRB process. So once they reach the end of the IRB process, they also have equal access to seek leave and judicial review of the courts. So I'm not able to speak to the relative volumes. I think it's fair to say there will be court challenges, but in terms of
Thank you, Ms. Hamilton. Sorry, that's time. Okay, next, our next 5 minute is with Ms. Rempel-Gardner.
Thank you, Chair. I just want to go back to the mass cancellation powers. In earlier testimony, you've outlined that these powers could be used in cases of fraud. Do you plan on using them should the bill pass to address cases of fraud? Are there any active cases that you would use this on?
We don't have any active plans to use it, no.
So there are no active plans at present to use the power whatsoever?
No.
So then why did you propose it?
We proposed it on the tail end of experiences that we learned through COVID, where we saw that there could have been a need to have a mass power to extend or pause documents, applications. And so we thought that it was a good idea to be able to respond to crises, emergency situations
So Ms.
in a
Lang, if
nimble
you're sitting
manner.
here, we're sitting here in 18 months from now, and I pull this testimony up, you guys won't have, and I'm doing ATIPs on you guys, there's nothing that you would have been planning to use these power for? Absolutely nothing?
So we have no plans to use the power. We're not going to turn around if the bill passes and start submitting an order in council. I mean, there are going to be areas of the department, there could be groups that come to us to say, hey, maybe we should look at this. Like, there's emerging threats on a daily basis.
I don't understand why it's in here then.
Because we don't know what's around the corner. So
Yeah,
we
but-
need
but
that
you- like,
flexibility.
I also don't understand why you couldn't use legislation.
Because legislation takes a super long time to pass.
But this is a pretty big power, right? That you're
It's-
asking for,
It's a
so
big
shouldn't it
power with
require?
a significant amount of checks and balances. It's not
How,
one minute.
because you don't come to Parliament through this, right?
Point d'ordre.
Point
J'adore.
of order. I love my colleague Michelle. However, for the health and safety of our interpreters, this is difficult.
Is if you have no plans to use this, and there wasn't really a circumstance in the past where you needed it, why we should devolve these powers to you without any parliamentary oversight? Like, you're not making the case for me here, and I'm honestly on the fence.
Right.
Mr. Zuberi has raised some points about defining the powers. Why would we give you these powers if you don't plan to use them? Like, give me an example.
So an example is 6 months from now, we have intelligence that, a country called Mike is planning foreign espionage, and we have received an uptake in applications. So we see that there's something weird going on. So instead of looking at these one by one, allowing these people to come into the country, tying up border offices, we could put in a recommendation to the Order in Council to say this cohort of applications with name Michelle Rumpel Gardner coming from Mike Country applied here, we will pause and we will review them and we will try to build a case to see whether or not this is a risk to Canada.
But don't you have that power already today?
We don't have that
You
power
do under
already today.
ministerial discretion,
We
though,
do
right?
not. We do not have the ability to pause any kind of processing of applications. Mass,
I think
case
you
by
do,
case.
Actually, I think you
Case by
do. I
case.
think if you look through it, you do. I don't think you guys have made the case, and that concerns me. I feel like you guys are hiding something, and that's the fact that you haven't defined the powers.
there's
that there's no reporting requirement. I think you guys kind of swung and missed on this one a bit. And I would encourage you to try and rectify that in the 48 hours that we have before we have to start amending this bill. Because you haven't satisfied me as a legislator. And I think that there are other people on this committee that feel the same way across party stripe. We don't trust you. And so we need to have, you said that there's checks and balance in this legislation. I don't think there's enough. I'll leave it at that. Did you provide any advice to the minister on any other measures to reduce incentives to abuse the asylum systems that weren't included in this bill?
I can't comment on advice to the minister. We're here to talk about the measures that are being studied by the committee.
You can,
We look at
No,
kind
you
of how the
can. You
system-
actually, that's a valid question for the committee. Did you provide any advice to the minister, yes or no, on ways to reduce the abuse of the asylum system that aren't included in this bill?
1 minute.
I mean, we look at the system all the time in terms of how is it working, what can we do to improve it, whether
What's
that's
not included in
procedural.
this bill that could reduce the incentives? How about, let's say, restricting the access to federal benefits to emergency health care for failed asylum claimants? Would that reduce the incentives to abuse the system?
I mean, there are many things that could be explored. There are also pros and cons to each of those. You know, individuals such as failed claimants who are here and potentially subject to challenges with removal may find themselves in health emergency situations.
That's
and
why I said
require
emergency
support.
benefits, right?
So,
What about the pre-removal risk assessment process? Why didn't you recommend, or did you recommend limiting pre-removal risk assessment appeals or a new pre-removal risk assessments to when there's substantive new circumstantial change?
so the pre-removal risk
Very
assessment
quick,
process
15 seconds.
for those who already have had an Immigration and Refugee Board decision only looks at new evidence that
Like
has
what?
occurred since.
Ms.
so any
Rumpel Gardner,
change-
I'm sorry. That is time, you guys.
Thank you.
We have to go to Ms. Soti.
Madam Chair, I will be splitting my time with my colleague MP Fred Scatos. But my first question is to you, Ms. Lang, and it's regarding the pre-removal risk assessment. Has IRCC considered strengthening the PRA process, for example, by guaranteeing access to hearing? And how is the department preparing potential backlogs or bottlenecks resulting from these new ineligibilities?
I'll actually pass it to my colleague, Mr. Holman.
Okay, thank you.
Yeah, I mean, the department is trying to ramp up operational preparedness. We are looking at making sure that we can move forward in delivering the pre-removal risk assessments as quickly as possible with trained officers, increasing the level of training that we're offering and being positioned to make sure that we can move forward quickly should the bill pass.
Thank you for your answer. We've also heard in this committee concerns that allowing the governor and council to cancel immigration documents in bulk goes too far, especially with public interest not clearly defined. How do you respond to these concerns, and why does IRCC believe that this level of flexibility is necessary?
Thank you for the question. So, as mentioned before, public interest is intentionally not defined in legislation to allow maximum flexibility for the Government of Canada to respond in a range of unforeseen circumstances that threaten the public interest. The intent is to protect the public interest, including integrity of our immigration system, safety and security and health of Canadians, the security of our border, or to respond to large-scale emergencies and other foreseen circumstances. These are meant to be used exceptionally when needed and are not planned. An example might include a pandemic, where the government may want to suspend visas for clients abroad to pause travel to Canada and protect Canadian public health. The suspension can then be lifted, for example, after the risk subsides or after clients provide evidence of a vaccine or a health test.
Thank you. Got about 30 seconds, but witnesses have also told this committee that the PRAW process is less thorough than the IRB process and often doesn't include the opportunity to plead their case in person. Can you explain why IRCC considers the PRAW process a reasonable alternative for those who would be ineligible to make an asylum claim under Bill C-12?
Yeah, as I explained, in our perspective, the PRAW process is a robust process. It has been around for about 20 years. It has been subject to court challenges in the past. I think the rate of cases that are failed PRAW cases that go to the federal court and are sent back for redetermination is only about 5%. In our view, cases do, or officers do look at the same protection factors. They receive significant guidance and training in order to do that. Clients have access to legal representation, and they look at the same country conditions as the IRB process. We do offer the ability to have a hearing. It happens in cases of significant credibility, so where the decision may hinge on an individual's circumstances or story. Otherwise, the paper-based process is an efficient process. As I mentioned earlier, country circumstances may and the level of state protection may allow for an easy yes decision, or on reviewing an application, and an individual's file, it may be straightforward to know that there's an internal flight alternative for that individual, resulting in a negative decision.
Thank you.
Thank you to officials for appearing. I do trust you, and I think we, around the table, there might be some exceptions on certain points, but thank you for the work that you do. In my experience, officials, like politicians, are loath to give hypotheticals, but this would be an exception. Can you give another example, Ms. Lang, of, on this point about cancellation of documents, where you think and where the government believes that this would be relevant?
Thanks. Sure. So, cybersecurity attack, where a vast number of fraudulent immigration documents are issued in the system, could potentially require a mass cancellation of the documents to ensure that nefarious actors cannot use them to travel to Canada. Where large-scale fraud trends were to be observed, these authorities could also be used to cancel or suspend documents and applications for documents based on known fraud indicators. Such actions would not be country-based and grounded in objective indicators linked to fraud. These authorities can also be used to change conditions on temporary residence in Canada to respond to social or economic matters that concern the public interest. For example, IRCC could modify temporary residence authorized length of stay and change employer-specific work permits to open work permits, allowing persons to work in different locations and fields across Canada where there is an increased public interest demand.
Thank you, Ms. Lang, and thank you, Mr. Frejascatos. Just because we have limited time left, with everyone's permission, I'll give 4 minutes to Mr. Menegakis, 4 to Mr. Frejascatos, and 1.5 minutes to Mr. Brunner-Duceppe.
Well, thank you. Thank you, Madam Chair, and thank you to our witnesses for appearing before us. I'm trying to get a handle on why you need the massive power of mass cancellations. You seem to have some concern that, or maybe disrespect, I might add, although that's a hard word to accept, I know, doing this through legislation. You commented that legislation takes a long time. Well, there's a reason why legislation takes a long time, because it requires parliamentary oversight, debate, review, in a lot of detail before we get to a point where we have a piece of legislation in front of us to discuss. And here we are today with a piece of legislation that, quite frankly, we were not expecting. And we do have it before us. You don't want to go through the legislative process. You want this massive power that can override what parliamentarians as legislators are really elected to do, is represent the people. So please explain why you cannot respect what's been done already so far, the legislative process, and now you want this massive power where you can say, this is good enough reason for me. Country Mike, country, Susan, whatever. I want to be able to have the power to do it without asking any elected official of the people to have an opinion.
Thank you for the question. I think that we have seen in recent times the world has changed, and we have seen such different emerging threats, whether they're health, whether they're safety, whether they're security, fraud, and the Minister of IRCC does not have this power unilaterally. The decision rests with Governor and Council, who acts on behalf of Cabinet. And also, on the advice of Cabinet, the Governor and Council will consider
1 minute.
all of the views of the Government of Canada collectively. So it ensures broad scrutiny, alignment with overall government priorities, and has a system of checks and balances.
We only have as you just heard the chair, so let me just get in on that a little bit. These are new regulatory executive power. The minister does have that authority because that's the minister that's going to prepare that memorandum to Cabinet and is going to go in there asking for the sweeping power without coming back to Parliament. At a time when Mr. McCrory has testified before this committee, there's already 30,000 people in the country that they can't find. Okay, at a time when we're talking about a one-touch system, that he has a different opinion than the elected person of the union of the employees that under Mr. McCrory's direction. They came here with a voice as well. Their morale is down. They're not happy. They're not satisfied. Mr. McCrory, you may want to paint a different picture today because you may be at odds with what Mr. McCrory says, but the fact of the matter is you represent the same people. So for us to overlook all of that and say, just give the sweeping powers on to the minister, the 7th minister in 10 years that can say, we want this minister, go in and get it for us from Order in Council, and ignore Parliament and the will of the Canadian people. You understand how difficult that is for us as legislators to accept, do you not?
So we have 30 seconds. Sorry, I was wrong with the time before.
So I really do think that the use of these powers could be handled in the public interest, and the Order in Council process with a whole of government approach, taking in considerations from all equal members is part of our government process, and I think that the checks and balance and the transparency is present in order to help this
I would
move
argue
through.
that it would be in the public interest not to have people with criminal records walking around the streets or waiting to complete their 45-day term so they can finish their
Thank you,
their
Mr.
screening,
Menegakis.
okay?
Thank you, Ms. Lang. We now go to 4 minutes with Mr. Fragiscatos.
Thank you, Madam Chair. I'll be splitting time with Ms. Sohi to make up for time that she gave to me. Ms. Lang, back to, did I say Ms. Lang? I meant Madam Chair. In any case, Ms. Lang now. Can you continue to give examples or expand on the ones that you've given? I go back to this point because I think it is absolutely central to this bill. Cancellation of documents is something that understandably has raised questions among advocates, including, as you see, members on this committee. But I think the examples can do the talking. Please continue and let us know as a committee what exactly this, through those examples, how this would ultimately improve Canadian security.
Thank you for that. Let me see. When threat actors are engaged in certain activities, they generally seek to disguise their intent and enter Canada singly to better avoid detection. So it is plausible that scenarios may arise that involve large cohorts. For instance, a foreign national, naval, or research vessel seeking access to Canadian waters and ports, an academic or trade business delegation, a large cohort of temporary visa holders entering Canada for a specific project or work in a specific sector. It's also plausible that foreign nationals could seek to enter Canada to participate in activities or events that constitute or contribute to threats to the national security or public safety. In these cases, the event or destination might be the key to identifying the cohort. The Governor and Council could issue an Order in Council to, for example, mass suspend documents while investigations are completed. This would eliminate the risk that such nefarious actors could travel to Canada. And this is one of the reasons why it needs to be nimble and it needs to be exercised in this manner, because it is on the spot and as it is happening. Another way that these authorities could be used to address, for instance, an immigration situation caused by a domestic natural disaster, such as an earthquake or wildfire. The authorities could, for example, mass extend work or study permits or amend permits to allow for working or studying in another region if this became necessary. It could also be used to quickly facilitate extensions of stay for temporary residents in Canada following a natural disaster or armed conflict in another country, leaving to return to the home country difficult or impossible. And again, as mentioned, the COVID-19 pandemic or other health crises, IRCC had to reissue several permits and documents to persons who had to stay in Canada longer than they had initially planned and needed to work to support themselves and their families. These authorities could have been used to extend the validity of those work permits en masse, which would have avoided significant backlogs that were accumulated in all lines of business post-pandemic and would allow us to continue to impact the economy in a positive manner.
1 minute.
The IRCC officials. We've heard that the new one-year ineligibility for asylum claimants introduced by Bill C-12 could disproportionately impact women, marginalized communities, and other survivors of gender-based violence. Can you tell us if IRCC has looked at how different groups like these may be impacted by these provisions, and are you confident that minority groups will be protected under this legislation?
Yeah, thanks for the question. I think I indicated earlier that we did do a gender-based analysis. Broadly, many of those groups would benefit from a fast asylum system. And then those directed towards the pre-removal risk assessment, we do train people on taking into account various vulnerabilities in dealing with sensitive situations as they go forward and interacting with clients, so that the pre-removal risk assessment can take into account specific circumstances that a client might experience.
Thank you very much. Thank you, Ms.
Madam
Soji. Thank you, Mr. Holman. 1 minute et demi, s'il vous plaît, Monsieur Brunet-Duceppe.
1.5 minutes, Mr. Brunet-Duceppe. Thank you. The bureaucrats who deal with asylum claims, are they the same ones who work for pre-removal assessments? Thank you for the question.
Specific officers who work on the pre-removal risk assessments, they receive at least 6 months of training and mentoring. And
Donc, ils ont une formation différente. Les fonctionnaires
So
qui
they have a different type of training. The ones who look at these pre-removal assessments are totally different.
You know, on the asylum claimants, we review eligibility.
C'est différent de la formation.
So it's different. Well, the decision on asylum claimants are made by the immigration committee, so it's different. Different training. Okay. Since the volume of cases that will be transferred to pre-removal risk assessment will explode, because you said that earlier, it will end up there far more, and since the training is different, the volume will transfer from one pace to another. It won't change overall, but it simply be transferred from one institution to another. And in addition to that, the training is different. So right now, there will not be enough trained officers for pre-removal risk assessment. So do you realize that not only will the volume not change, but in addition, the deadlines will explode because there's a lack of training if C-12 is applied?
Trained officers who are already implementing the pre-removal risk assessment program. They would be those who are working on.
Vous nous avez dit que le volume allait exploser.
But you told us the volume would explode.
Then it's time. Just 15 seconds, please,
Sure.
Mr.
Thank you, Madam
Holman.
Chair. We are also increasing our operational capacity. We've already been working on increasing that capacity with additional training and additional staff capacity to make sure that we're ready for the higher volumes.
Merci, Monsieur Brunet-Duceppe. Thank you, Mr. Holman. All witnesses today. Really important for us to have you back today to answer a number of questions that have come up over the last 3 days. Thank you so much for the work that you do. Thank you for being here. And with that, I'm going to suspend for 5-10 minutes so that we can come back and then go in camera. Thank you.